Everyone. We hope you are enjoying your work from home situation. My name is Rich Lenkov. I'm an attorney with Bryce, Downey, and Lenkov. I'm also a board member for ClaimsXchange, and this will be the second video that we put on our ClaimsXchange channel. We hope to be your go-to resource for all things claims, all things risk management, and especially in this time, we've got a lot of great feedback from a lot of folks on our first video that was released a couple of weeks ago that dealt with, in the early days of the coronavirus, how to deal with a workers' comp claim. We heard from a really excellent doctor. So today's video, again, deals with workers' compensation and how to deal with the impacts of a corona claim, not just a corona claim, but even claimants who don't have the virus, the impact that this virus is having on those claimants. So we are very privileged to have one of the foremost workers' compensation attorneys in Chicago. Her name is Jill Wagner. She's with Disparti Law Group. I want to make sure I get that right. Yep. And we're very lucky to have her. Welcome, Jill, to the webinar.
Hi, thanks for having me.
So today's presentation is going to cover 3 or 4 what we consider hot topics. And we're going to present to you both our side, which is the defense side. I'm obviously a workers' compensation defense attorney, and then we're also going to present to you the other side. Jill and I have known each other for years. We've had a lot of cases against each other, and again, she's one of the best attorneys out there. She's very passionate and knowledgeable about workers' compensation, and of course, we disagree on a lot of areas, especially as it relates to the coronavirus. So we hope to present a very spirited back and forth on some issues, understanding, of course, that this is new. None of us have all the answers. None of this has been litigated, obviously. So like in most new areas of the law, a lot of how the courts will interpret this will be decided by case law. So with that being said, we'll talk first about what I think is the most important issue, dealing with people who have corona claims. Again, we'll start off with dealing with claimants who are alleging that they have the virus and that they got it from work. So obviously, the first question there is, how will a claimant prove that the virus arose out of and in the course of their employment? And by the way, even though Jill and I participate or practice law in Illinois, we also do Indiana. These concepts pretty much apply to whatever workers' compensation practice or venue that you're in. So we think these themes are universal. So like in any jurisdiction, it's the claimant's burden to prove that the virus arose out of and in the course of their employment. And I frankly think that's an almost impossible burden. How will you, as a plaintiff's lawyer, Jill, pinpoint that your client developed this condition from work versus everywhere else in the world? What do you think of that? How are you going to prove that?
Sure. I think really what we'll be looking for is first and foremost employees who are at a greater risk than the general public. I think obviously that's key in order to us proving a case. Okay. I acknowledge that I think causation will be difficult, but for these people, especially these essential workers, especially here in Illinois, that's what I can touch on, that are out there every single day and again exposed to this greater risk. I think that's first and foremost. So talking about, of course, the healthcare industry, I think that's probably the most obvious, the nurses, even nursing homes, CNAs, doctors, etc. But there's also other categories we're looking for, people in travel, whether that be at the airport and they're doing the ticketing, even the cleaning crew. I mean, that list is very extensive. Especially in Chicago, looking at CTA workers, these people who are still running every day and are at the greater risk, not to mention hotel employees, the ones that are still open at least. Same thing even with grocery store workers, okay? We basically just have to prove that being at a greater risk than the general public, which I think is pretty clear, seeing as how the rest of us are in shelter in place and they have to still be working. As long as it's a factor, I think that we have a good case there to prove causation.
Yeah, I think it's really interesting. I think, generally the analysis of whether the employee faces a greater risk than the rest of society is the key question. In other words, if because of their employment, your claimant faces risks greater than everyone else walking around the world, that's generally enough to prove accident in Illinois, as in most states. But I think it's a little different in this case because, you know, Jill is correct. There are certain classes of employees, all of which she named, plus grocery store workers, you know, Uber drivers, whoever, those people who are actually working full time now, they will have a strong argument that they are exposed to a greater risk. But I think personally that that's not the end of the story because of the fact that you can get this virus anywhere. So even if you're a healthcare worker, even if you're a grocery store employee, I think in this unique circumstance, the mere fact that you can prove to an arbitrator that you're at a greater risk just because you're working when, you know, most of the world is not working, the fact is it's so hard to prove accident with the coronavirus because you can literally get it everywhere. And how are you going to prove that just because you were at work, you got it there versus on the bus on the way home, or when you were walking your dog, or touching anything else, touching the handlebar, you know, walk or the doorknob walking into your house. So my advice to my clients right now is to deny those claims. I think they'll be very difficult to prove. And, you know, remember, it's always Jill's burden, as she'll acknowledge, to prove all the elements of her cause of action. It's not our burden as the defense to disprove anything. But Jill, talk to the concept of the sympathy factor. I mean, listen, we all consider people who are working now in essential services, especially healthcare workers who are doing, you know, incredible work at a high degree of peril to themselves by working now. The mere fact that you're in a hospital working means that you're doing incredible work. Talk to the power of the sympathy factor, even though maybe the black letter of the law is as I say. Do you want to be the first respondent who denies the corona claim from someone who's working in the ER? Talk to us about how important that factor is when, you know, practically litigating these cases before an arbitrator.
Yeah, I mean, I think ultimately that will come into play. You know, I think that right now in times of crisis, I think that everybody wants to help where they can. You know, whether that's the insurance company, the arbitrators, et cetera, they don't want to use this. I'd like to believe nobody wants to use this as time to deny claims or to come out and be unreasonable. So I think even if it's questionable, I think, and I've even been seeing it in conversations I've been having, people seem to be kind of skewing towards finding compensability to exactly what you're saying. You know, people are helping us in this time of need. I think they're trying to also help back. I think if we're going to be litigating it, I think arbitrators will do the same thing. You know, some of them are having to be forced to work currently now too. You know, there are some arbitrators that are the emergency arbitrators, so to speak. You know, I'm sure they don't necessarily love being those arbitrators on call. So if they went through it, they understand what's going on and they see the seriousness all around us. I think absolutely that will play, especially like I was saying, if it's 50-50, I think it's going to tip in favor of the injured worker, in my opinion. Yeah,
the arbitrators working is a really great point. So moving on to causation, you mentioned causation. Remember, our listeners should remember that, you know, it's easy and it's not uncommon to conflate accident and causation because they sort of seem like the same issue. But remember, those are two separate issues, and both of them are essential elements of Jill and any claimant's attorney's cause of action, and they're separate and distinct. And if Jill doesn't prove both of those, then she loses. So, you know, think of it this way. Accident is generally a legal issue, and causation is usually a medical issue. In this case, though, I think to Jill's point, I think generally if you're going to lose on accident, then you're probably going to lose on causation. In this case, because of the nature of the virus, they're so closely related that, you know, they're going to be part and parcel of the same issue. So I'm not saying don't fight accident. The opposite is true. I still think you should generally fight these cases and make claimants' attorneys prove their cause of action. But I'm not clear yet how a doctor would say that, yes, the patient developed the virus from work, but their condition is not causally related to that. I think in this case, the two are pretty much the same thing. Jill, what do you think on that?
Yeah, I agree with you on that.
All right, so let's say Jill is successful, proves accident, proves causation. That means you're paying benefits while the employee is off work. We'll get in a moment to non-corona claimants, because that is right now the biggest issue. But you've paid them benefits. The next question in any of these claims is, what is the permanency value? I touched on that a little bit in my video with the doctor last week, but that's, I think, another, another part of that to remember is it's always claimant's burden to prove the elements of their cause of action, and permanency really is a three-part test when you think about it. It's an acronym here in Illinois. It's permanent partial disability. And that is a three-part test, not just an acronym. So petitioners have to prove permanent partial disability. And my position so far, again, in the early stages of this virus, is where is the permanent partial disability for this condition? We know that if someone has surgery, for example, to their arm, they're probably going to have residual issues, for some period of time. Not always, but with this virus, we know generally that the symptoms are dissipating within 14 days. So I think even if you've got a compensable accident, the permanency value of this condition will be very low. And remember, just because it's Illinois doesn't mean that every injury has permanent partial disability. As you've heard me say on many webinars before, you can, win a case in Illinois based on permanency and take the position that even though it's a compensable injury and there was some treatment, the permanency value is zero. So I think the permanency value of this condition will be very low, if not zero. But Jill, tell me why I'm wrong on that.
Well, I mean, it's such a range, right? I think that, yes, there are some people, thankfully, that are able to get better and go back to work. Obviously, there's still the medical bills and the off-work benefits, which I know is not what we're talking about right now, but that could be astronomical and make a huge deal to these injured workers. But, other people, unfortunately, are dying. But beyond that, I think that we don't even know what the long-term effects are yet, especially with these people who have the underlying condition. I think some of these doctors are saying that ultimately it could have a long-term effect on the lungs. Okay, so that's obviously something that may need to be litigated, something that we're going to look at it closely, especially in the next coming weeks and months, and seeing how these people are responding. But I think ultimately, you have a point that those are the types of cases that ultimately would have the most permanency, the most value to their cases.
Yeah, I think you raise a good point. And one where we'll see some friction and litigation on causation is people who had underlying or pre-existing lung issues. To what degree did the virus cause their death or their long-term damage versus their pre-existing condition? Guaranteed, right. You'll see, that being an issue, especially with smokers or, vapors, people who did have prior issues with their lungs. We will definitely litigate that and not just accept that it was this virus that caused it. And of course, as Jill mentioned, unfortunately, a claimant who dies from this condition, that's the easy case, right? The value of that, and there's some, whatever state you're in, there's always benefits to the dependents of someone who dies from a work-related accident. All right, so that gives you a guideline, or maybe, some different opinions on some of the issues for claimants that have corona. What about claimants today? I think the more common situation that we're all seeing is a claimant who's, treating off work for some other condition, but they are not, their whole life is turned upside down, as all of ours is, because of the virus. So an example is, we're getting this question every day, what do you do with a claimant who is off work, collecting TTD, temporary total disability, and treating, and suddenly they can't go to their doctor because the doctor's office is closed? I'm going to turn this over to Jill, and then I'll give you my response. But Jill, I'm sure you're seeing that with some of your clients. What is your argument to the employer, and are you getting any pushback on that issue?
Yeah, absolutely. I am getting a little bit of pushback from some adjusters. I think absolutely TTD should be continued. It's not our client's fault that the doctor's offices aren't open, to the general risk of everyone else. Okay. I have seen, though, that some doctor's offices seem to be kind of changing with the trends and doing at least some therapy virtually. like similar platforms like this, and some can do virtual doctor's office like this, but I don't think all of them can. In the event that they can't, you know, I think ultimately it could be a penalty situation for the insurance company if they're not going to continue paying TTD. To me, that's unreasonable and vexatious at this point.
So it's a tough one. You know, again, the black letter law says that if a claimant is not treating, then you don't have to pay them benefits, right? It's a two-way street. They get benefits, we get the benefit of them advancing their case, and they have to go to the doctor. So you can look at this as, listen, it doesn't matter what the reason is. They're not treating, therefore we don't owe benefits. Will that win? Is that a penalty situation? Those are two separate questions, by the way. You know, you can choose a course of action that might not be a winner at the commission, but doesn't creep into the level of vexatious or bad faith, and therefore subject to penalties. I think Jill's probably right. I think for a couple reasons. You know, the commission, we're all under an order from the chairman of the commission a couple of weeks ago where he said, listen, we're in a time of crisis. Try to work things out. We have limited resources. We have limited hearings. So do what you can to work things out on your own. By order of the governor, his boss, we don't have the resource or time to litigate, you know, smaller issues. Is this a smaller issue? Well, you know, maybe not, but it's certainly one that can generally be worked out among the parties. So again, maybe the black letter law says deny benefits, cut them off if a petitioner's not treating. But do you want to be the first respondent, the first employer to go try that issue? Probably not. Right now, I think you'll probably lose that issue. Now, are there alternatives? I will say that, you know, you should tell the claimant, get another doctor. There's nothing wrong with telling the claimant that maybe your doctor is not seeing patients, but, you know, here's other doctors, and maybe you help them. Maybe you get a list together of doctors that aren't seeing patients. Now, that has to be reasonable. They have to be, you know, qualified doctors. They have to be somewhere relatively close. If you do that and claimant still refuses, then I think you've got a strong case for denial. Now, by the way, remember in Illinois, the claimant has the choice of 2 doctors generally. I would waive that and say, okay, you've used your 2 doctors, but I found a 3rd doctor who's qualified, relatively close, see that doctor. If they refuse, cut them off. I would also offer what Jill said, which is telemedicine. That's obviously an area that's growing by the day, and I would not rule that out. I would offer that as an option before you just accept they're not going to the doctor. The third thing I would try is an IME. There's more IMEs seeing patients now, and maybe you agree with claimant's attorney to have the IME doctor become the treater. But there are options that you can pursue. I think the overall theme is try to work it out. These are not issues that you want to litigate as an emergency right away. All right, the third issue, and I just touched on it a little bit, and then we'll let you go, is IMEs. You know, Section 12 examinations, as we call them here in Illinois, that's one of the main tools that we have as employers, as respondents, to move the case forward. If the claimant doctor is not releasing a claimant, or if they're not treating them as aggressively as you'd like, or if you think the claimant is malingering, those are just 3 of the many reasons why you would get an IME. Well, what happens now when you can't get an IME? Or you can't get an IME because the doctors are not seeing patients, or the claimant refuses to go because of fear of leaving their house. You know, that's a tricky one. Again, I think the black letter of the law, Section 12, says we have the right to an IME, and if they don't comply, then you cut them off. If there are doctors still seeing patients, which there are some, I would stick to the idea that Section 12 mandates that you go to the IME, and if you don't, then we get to cut off benefits. Jill, how do you respond to that?
Yeah, I mean, I think that I'd probably disagree right now. I think that it would be more reasonable if there wasn't a shelter-in-place order issued. I think that if my client called me and told me, listen, I don't feel comfortable going to this appointment, I think that's reasonable right now. Now, I think if there wasn't a shelter in place, maybe 4 weeks from now, assuming that all is back to normal, I think that argument's not as strong. I think at that point, if they're still saying there's some residual effects, I would say, you know, I think you're right, Rich, there. But I think at the moment, I think that that would be unreasonable.
Yeah, I mean, I think to Jill's point, you know, remember that there are these shelter-in-place orders. Many have, you know, criminal penalties for non-compliance. So are you arguably breaking a state or a local, not yet a federal, but, you know, soon could be a federal law by forcing someone to go to an IME? Maybe that's a pretty compelling argument. All right, last issue I just want to touch on really briefly, more of a practical thing while we have the benefit of Jill, is, you know, how do you use what's going on now as an asset to move your case forward? Listen, we all want to move our cases forward. Believe it or not, even the Jills of the world, you might not think so, but she has every incentive to move cases forward too. A lot of you are in states where it's very difficult to get plaintiffs' attorneys to get back to you sometimes. You've got an offer and they don't respond. But now's a great time to settle cases from both perspectives, right? What I'm telling a lot of claimants' attorneys is we don't know what's going to happen in the future. We don't know when we're going to get back to normal. Obviously, we don't know when hearings are going to happen. Hearings are generally the engine that drives a lot of resolution. So take some money now. I'm not saying take pennies on the dollar. You know, we'll make a fair offer, but take it now. Let's cut out all the, you know, general back and forth that ties these cases up, and let's get your client some money today. That's been working sometimes, not always. But Jill, what's your perspective on, you know, now is a great time to settle versus dragging things out?
Yeah, absolutely. I think first and foremost, we're not in court. So I think that in terms of, you know, sitting down, going through these files, getting rid of them, I think that now is a great time. But I also think practically speaking, I mean, business is business, whether it's for the law firm or even for our clients. I mean, a lot of these people are going through really tough times right now. And let's say they're towards the end of their treatment, they're looking to settle now. And maybe to the advantage of you guys to a little bit, but also to their advantage if their families need money for whatever reason, if their loved ones aren't working, etc. I think that now is the time ultimately to maximize that.
All right, great advice. Great thoughts from Jill Wagner. Jill's with Disparti Law Group. Again, Jill's a frequent opponent of ours, but always handles things, we think, very fairly, and just a great lawyer. So Jill, appreciate your time, and stay safe, stay healthy.
Thanks, Rich. I appreciate it. You too.
And thanks everyone listening, and stay tuned for more of these educational videos on ClaimsXchange. Thanks very much.
Thanks.